Okay, what would be better, doing a rent-to-own or a traditional finance for a potential tenant buyer? A traditional finance for a tenant buyer or rent-to-own? It does depend on the numbers, but I want to know what you mean by the distinction. Doing a rent-to-own or a traditional finance for a tenant buyer. You finance for them, is that what you mean, Dave? Doing a VTB, a seller financing for them? Oh, okay. Well, I mean, if you're doing a mortgage for someone, you're talking about you have a property, it's got no mortgage on it, and you're gonna finance for them. Is that what you mean? Yeah. Okay. So you know what? I would say that if you're doing seller financing, it would be to the benefit, Dave. It'd be more likely that you'd be doing that for tax reasons or trying to get a better or bigger price for the property. Let's see. No, I would be buying a home and doing a mortgage for them, probably 3 to 5 years. So, Dave, you mean paying cash for the house? So there's no mortgage on the house, right, Dave? And you're going to do a 3 to 5 term mortgage. I would have a mortgage as well. Okay, that's called a wrap mortgage, or in some you might have heard a different term. You have to make sure that you're not violating the contract or agreement you have with the banker institution, that you're allowed to do something like that. So you just want to make sure you're not violating the agreement. Yeah. So in doing that, having a mortgage, which I would absolutely say yes to, have a mortgage. It's better for us to have the mortgage because the security, the debt is really held by the lender, not you. The risk of the debt is a better situation for us. Obviously, less money and capital in the property is better for us for the return on investment. So you're on title, yeah. I totally understand what you're saying. Profitability wise, I'm gonna just as in general, the rent to own is gonna be more profitable for you than the holding the mortgage. We'd have to run the numbers, obviously, but I think it would be better security wise too. Also, Dave, that if you to run a rent to own, have a lender hold the majority of the debt on the property would probably be a better approach numbers wise. Obviously, again, we'd have to run the numbers, but the security part of it for sure, I'd want the institution to hold the bulk of it. If in a situation where we'd have the property completely paid off for whatever reason it happened, then I would say the VTB might be an option, seller financing, to help us get a better price, overall price for the property. And doing the mortgage on it, not a bad idea at all. It's just it would be more for the function of taxes than profitability. Does that answer your question? Yeah. Okay. Yeah. But you'd have to measure that against, Dave, what you would get than the bank. Yeah. Sure. Yeah. Absolutely. That's the spread that you would be gaining from the wrap. So you'd have to run the numbers on that, Dave, and make sure that you're not. So for the second mortgage, Dave, or the first, or all of it. So if you'd have to, you know what, I would think that some guidance from your attorney on making sure that you don't violate the agreement and commitments you've made to the lender, that you can do something like that. That's the only thing I would tell you. Just don't expose yourself. Yep, totally get it. Yep, that's like a wrap mortgage. That's exactly what a wrap mortgage tries to do. Exactly the same thing. Yeah, for sure. Maybe Tara can give us some feedback on that. Donald, you said something about, okay, does rent to own need to use our own name or company's name? So Donald, you know what? I'm going to defer that to Adnan. Adnan will share with us about that. And yeah, for sure, Dave. And also, Donald, we've been going back and forth in emails. The last one we had was the profitability of the property. You understand that what you're giving up, they're asking us to drop the price, the interest. So just so everybody knows, Donald is working on a rent-to-own, and they're working on rent-to-own, and they've worked out 4.5% as the appreciation rate. Just want to make sure. It looks like it's going to be a 1 year, or is it going to be 3 years? Do you think it's going to go the full 3 years, Donald? Yeah, 3 years. Okay, so just to give you an example, so the person's asking for a drop from 4.5 to 3. Yes, 4.5. Sorry, from 4.5 to 1.5. Correct? Okay. Here's our challenge. It's not really a challenge, it's just the math. Okay. The property is 550. Okay. I want to double check something too. Okay. Are you paying 550 for this property? What was your original price that you're purchasing this property for? Is there any money in the buy? Is what I'm really asking. Okay, so that's the first challenge. There's no money in the buy. Okay. So if we're giving up, just to give you an idea, if we're giving up 3%, if we're giving up 3% per year, compounded, what is that in cash value? What is that in cash value? So what we can do is this. Why don't we do this to simplify it? I don't want to complicate it. Real simple. Look at this. The original was 4.5, correct? 4.5, okay? So if we compound that, would you see what I'm trying to do here, Donald? I'm trying to understand the impact of that change. So 550,000, the term is 3. Sorry, the interest is 4.5, the term is 3. And then we see that will be 629 021. Okay? Okay? Now this is what I want you to do. Now let's go versus 1.5. What's the impact? So if I change the 4.5 to 1.5, okay, and I calculate that, now we're at 575,266. Okay? So what's the difference between these two numbers? If we calculate the difference between the two numbers, 629,021 minus 575,266, it's 53,755. Okay, do you see that? Okay, so that's what we're giving up, Donald, by moving the interest rate from 4.5 to 1.5. Okay, so really, because there's no profit here, right? This is really the profit that we're getting, the 53. Okay, so if we drop that to the 1.5, then we're only going to make $25,266, which is what? Which is this here, this, right, and this, right? So we're looking at, this is the end number, and this is the first number. So the difference between these two would be 25,266. So we're giving up about half the money, actually more than half the money up for what? The sellers, the tenant buyers offering a 10,000 more in deposit, which is a benefit to us, right? Instead of them giving 10,000, they're going to give, or 10%. My apologies, they're going to give 20%. There is a benefit there. There is a benefit for us because that's less we have to worry about in the way of financing the property. But we have to measure, if this is worth it. Now, as a rule, we'd like to do what? We'd like to get about 20,000 per year on a lease option, a rent-to-own. Now, we're right on the edge with the 53,755. We're there, but I don't know if it's worth it for us, Donald, to drop it to 1.5. Now you could find some middle ground. You could say, look, 3.5. If you give us 20%, we'll drop it to 3.5. If you remain with 10%, we'll go 4.5%. But I don't see the value for 25 grand, because that ends up being around what, 7,000 a year. Now it's not terrible, but remember, you're taking $600 in non-refundable option consideration per month. So basically, the non-refundable option consideration that you're taking, the $600, that's almost exactly the profit you'd be taking per year on that property. So you'd be collecting the end profit per month over the 3-year period. In other words, there'd be nothing left at the end of it. You'd still get the money, the $25,000, but it would be the $600 per month. You understand what I'm saying? Does that make sense? Okay. So I want you to think about whether this works for you profitability wise, because we got to remember, for sustainability, both of us have to make money, right? But it has to be a good deal for both the tenant buyer and ourselves, the seller and the buyer. This is important for us to look at. So we can I want you to look at that. Why don't you guys look at that, work on it, tell me what you think, send me an email, and we'll continue this conversation. Okay. So what I want to do is I want to let Ed jump in, because we only have about 17 minutes with him left, because he's got to step away at 10. So I want you to move in the direction of legal questions. Okay. So I'm just going to let Ed do a quick intro, and then we'll start with those legal questions. Okay.
Okay. So just by way of a quick intro, while people are coming up with questions. So my name is Adnan Shabar. I'm a corporate commercial lawyer who does a lot of contract and contract-based work. I've been doing it for about 15 years, and I see deals like this all the time. I mean, there are always nuances, and it's a bit different. There aren't sort of template from one deal to the other, but the basics and the basic principles apply almost universally across the board.
So Vince, I'm gonna tell you to hold off on that one. We're gonna right now, everyone, here's your opportunity for any contract or legal questions, okay? Adnan's here for a short period to take advantage of it. Anything about corporations or corporate law too? No worries.
Anything about corporate structuring?
Corporate structure.
Anything about the dynamics involved in setting this up, the functions to be served by setting it up, why corporations are set up this way.
So we had the question earlier about the rent, a rent to own, if the property should be, in your own name or a company's name. I would always lean towards, and I'll defer this to Ed also, but I would always lean towards putting it in a corporation, just to create that layer of protection, that insurance of liability versus your specific your own assets in your own name. Do you want to just
so there's a layer of protection there, but there are also tax issues as well that need to be canvassed with whoever your tax accountant is. Strictly speaking, purely from a corporate law perspective, and that considers the issue primarily of liability, the corporate route is the better route, but that isn't the determining factor all the time. You have to consider both the tax issues and the liability issues. Those are the principal issues. I mean, there are other issues too, depending on the deal and the dynamics of the deal and the players and the objectives to be set. If we are just starting the business, should we create the 3-tier corporation right away? If you're acquiring real estate, depending on what you mean by starting the business, if by that you mean by acquiring a property, yeah, it makes sense to start right away. Each of the 3 corporations serves a function, and to the extent that you don't have one of those corporations, you're going to lose the function to be served by having that corporation. So whether it's 1 property or 10 properties, I mean, the quantum of the benefit, right? The liability protection is always there. It applies across the board, whether it's 1 or 10, right? Different considerations as well that depend case to case. But from the tax perspective and the benefits that are enjoyed, because there are tax benefits as well, the quantum of the tax savings or the tax deferral would depend on the numbers involved. What would be the easiest way to transfer an existing property into a new formed corp? doing it on refinance. I mean, that's one option, right? You can do it on refinance. You can do it anytime, right? There are certain sections of the Tax Act. Again, so the liability protection is there if you transfer the property to a corporation. You're automatically insulated, right? But there are certain tax considerations on any transfer, right? And I'm not the right person to talk in detail about this. This is really a tax-related question, but you've got to consider, for example, on the transfer, the land transfer tax, for example. Now, there is a little-known provision of the Land Transfer Tax Act that will allow you, and I don't know the details of this, but it will allow you to avoid paying the land transfer tax if you're transferring the property from your name to a company that you control, right? So you own most of the shares that hold the voting rights attached to them, right? Shares can have voting rights, they can have super voting rights, or they may not have any voting rights at all, or you can create shares with any classes, you can create any class of shares with a variety of rights. I mean, the rights are about as the possible or potential rights associated with shares are as broad as your imagination. But anyways, so there is a section of the Land Transfer Act that will allow you to avoid paying the land transfer tax, and it goes something like this. And again, this is a question better asked for an accountant. What you would do is you would determine the land transfer tax payable on a transfer, right? Anytime there's a transfer of property, the land transfer tax is payable. What you would do is you would pay that amount of land transfer tax. Let's say it's 10 grand on a parcel of property, right? You would transfer it from yourself in your individual capacity, or if you own it with somebody from joint ownership to a corporation, you would pay this amount, the $10,000, which would otherwise be payable as land transfer tax. You pay it in trust, which just means you pay it, but it's held there. It's not, you haven't given up rights to that 10 grand. The money is held in trust, held by somebody else for your benefit for a period of, I believe it's 3 years. I'm fairly certain it's 3 years. And to the extent that the property after that 3-year period is still held by the corporation, then you get a refund of that money. So the cost really is of this, in terms of just land transfer, right? The cost really is just the carrying cost of the land transfer tax amount for 3 years. So you'll be reimbursed that amount, but you won't have use of that money for 3 years. If you borrow it, it's the carrying cost, and if you don't borrow it and you have it, it's your opportunity cost. What else you might have been able to do with that 10 grand?
So the main thing, I think the point being made, in addition to the other points that Edna made, we have to consider the numbers. We just had to consider the numbers and see if that's the best approach for our business and measuring it against the liability.
So Michael from Calgary's got a question. He says, at what stage during closing a deal should I create a corporation for my property protection? Okay, so in terms of timing, so just quickly, and I won't go too much into legal theory here, but just quickly, what you're doing in law when you're creating or incorporating a company and filing articles of incorporation is you are bringing into existence a legal person. A corporation in law is a legal person, so you're bringing it into existence. In order to close the deal with the benefit of having that corporate entity as the owner of the property, the corporation has to be in existence just prior. It can be just prior, but at some point prior to closing. So what I normally recommend to clients, because there is an expense associated with incorporating a company, and this applies across the board, whether one is investing in real estate or engaging in any other business venture, it makes sense to wait until you're at the point where you're fairly certain that you're going to acquire the property. So for example, if we do deals all the time, which may or may not include real estate, right? And what we will do is we will wait until we have a fairly firm deal, right? Often deals will come with conditions. Certainly, real estate transactions often have conditions on them. I don't know that it makes much sense to incorporate a company before you have a firm deal, and by that I mean conditions have been waived or satisfied. An alternative strategy is if an individual knows that they are going to be engaging in real estate investing, and they know that whether this deal closes or another deal closes at some point in the future, they're going to be investing in real estate, then there's no reason not to do it right away, right? You can, one can enter into a agreement of purchase and sale, conditional or otherwise, in their own individual capacity. So Adnan Shabar would be the purchaser, but you would always want to include language in there that makes it clear that Adnan Shabar, or whomever the purchaser is not liable for the obligations in this agreement, and that Adnan Shabar is simply holding the rights associated with this agreement in trust. Again, there's this concept of in trust for a company to be incorporated later, and you would go beyond that. If it were properly worded, you would go on and say something along the lines of Adnan Shabar in trust for a company to be incorporated without any personal liability. That's best practices. Strictly speaking, from a first principles perspective, from a legal perspective, you don't need to do that. It is best practices. The reason I say you don't need to do that is because the law says that any and all contracts, virtually any and all contracts, there are always exceptions in the law, it's never black and white, but virtually all contracts are assignable. An assignment is simply a transfer of rights from one party to another, right? All contracts are assignable unless the contract, the terms of the agreement preclude assignment. So the default rule is all contracts are assignable, save for a contract that's entered into which limits to some extent the assignability of the contract. The reason it's important to include that sort of wording in there, Adnan Shabar and trust for a company to be incorporated without any personal liability at all, is the legal rule is all contracts are assignable, all contractual rights. To be clear, all contractual rights are assignable, right? So if Adnan enters into an agreement of purchase and sale, he has the right to assign his rights in that contract. What would remain, however, is those obligations, right? So I could assign my rights to the corporation, but I would still have the obligations associated with that contract, which is why you would want to include that wording, Adnan Shabar and trust for a company without personal liability. So it's patent to both the buyer and the seller that Adnan is only holding this property in trust. I've used the term trust a few times here, so just let me tell you really quickly, again, with not getting too involved in the legal theory behind it. I don't want to get too granular on this, but what trust, let me just explain to you what I mean by trust so everybody understands, and if there are any questions, let me know. So in common law jurisdictions, which is every single province other than Quebec, Quebec is just a different beast, you can bifurcate, you can separate ownership, right, into either legal ownership or beneficial ownership. Most people who own something have both ownerships, both the legal ownership and the beneficial ownership. So for example, my car is in my name, my house is in my name. I have both legal ownership. Legally, it's registered in my name, and beneficial ownership, so that's what legal ownership means. Beneficial ownership means he who has the benefit of that property. Now you can separate those two, right? So when I'm purchasing a property in my name and trust for a company to be incorporated later without personal liability, the agreement is in my name. So legally, I have legal title and I have the benefit of the legal rights associated with that agreement. But the true beneficiary of that agreement, the person for whose benefit the agreement is entered into, is the beneficiary. So you can separate ownership like that, and then at closing, you register in the name of the corporation, and now the corporation has both of those types of ownership, both legal and beneficial.
Let's go right here.
Instead of a three-tier corporate structure, is there a more affordable structure that still? I mean, so you're talking protections. So that question there is limited, and if I'm misreading the intention behind the question, let me know. If you mean by that to protect you as an individual and to insulate your personal assets from sale and seizure in the event that some liability, in the event that the real property, the real estate attracts liability, then you would be protecting yourself and your assets simply by using one corporation. What you wouldn't be protecting, though, and what you wouldn't be achieving are the tax benefits from using the corporate structure, right? So you wouldn't be protecting the accrual of profits that are made, right? You need all three corporations in order to benefit from the tax savings associated with the lower tax rate paid by the second of the three companies. You've got your holding company, you've got your real estate. So the H in this sort of pyramid here at the top, that's the holding company. Holding company doesn't really mean anything at law. What people usually mean by a holding company is a company that has a passive investment, right? Passive investment, for example, is shares. From a legal perspective, the importance of that is let me just step back 1 second. The general rule, not the general rule, the rule, but it's the general rule, is that anybody can sue anybody else at any time for any reason. So even a holding company that's holding a passive investment, anybody can sue anybody at any time for any reason. That is the law, period. So the proper question isn't, can I get sued? Because the answer is almost always, virtually always, yes. The proper question is, to the extent that I do get sued, what are the chances that I'm going to face liability? The chances are extremely minimal. And in fact, I've been doing this for 15 years. I've never seen a holding company be liable for any damages. Damages are awards that are held by a judge in the context, well, I guess, of either litigation or arbitration. So you've got your H, the holding company there. R is the real estate company. That's the company that holds the land. And then you've got C, your consulting company. The benefit of the consulting company is that it's paying a significantly lower tax rate than the real estate holding company. Real estate, if you have a company, and by real estate holding company, I mean a company that does nothing virtually but hold real estate, you're paying tax at basically the highest rate. There are certain situations where you would pay a lower rate. It's around 14-15% now. If you are what we call what's termed in the Income Tax Act as a CCPC, Canadian Controlled Private Corporation, which means just that. Canadian Controlled means not more than 50% of the shares are held by a non-Canadian. Private corporation means you're not offering your shares to the public, and you guys wouldn't be. The consulting company, which is the C box under the holding company, is a CCPV. It's a Canadian Controlled Private Company that's operating an active business. It's managing it's providing consulting services to the real estate company, pays taxes at the lower rate. Just to tie the loop and finish what I was saying before about the real estate holding companies. Real estate holding companies, companies that do nothing but hold passive real estate, can also be CCPVs, but there are certain rules that are applied that probably wouldn't apply to any, or at least most of you. You have to have either 5 or 6 full-time employees in the real estate holding company. That's the big rule that makes most real estate investors offside, because they don't have that number of full-time employees, and therefore they're paying tax at the highest rate. What would you recommend is the ideal number of properties to be held under this thing? So this is really a liability question, and I think I may have touched on this. I was on this call about a month or so ago. So the question is really liability, right? So and there are a couple of schools of thought on this. There are some lawyers that think that every single property should be held in a separate entity. And what you do, so again, you silo the liability in a company, right? So if a company, let me give you a quick example that's not directly related to real estate, although there is a real estate component, and then I'll try to answer your question directly. And if I miss something, just pop a question in that rectangular area there. So we had a client. I had a client several years ago who operated an automobile dealership. And so in order to try to silo the liability of each part of the automobile dealership, and I'll tell you what each part of it was in a second, we created several different corporations. So his greatest asset, or one of his greatest assets, was the land, right? The land from which he operated, which he owned, right? So we had a company that owned that land and did nothing except engage in leasing transactions with a couple other companies that I'll describe in a second. So you've got one company that just owns the land, and it silos all the liability associated with that land in that legal person, right? You can't go after person A if person B is indebted to you. You can only go after person B. I've got a brother. If my brother owes you a debt, you can't come to me and say, hey, pay your brother's debt. It's not my debt. Go deal with them. Similar to corporations, because they're legal persons. So we had one company that owned the land. We had another company that owned the new car dealership. We had another company that owned the used car dealership. We had another company that owned the garage, the mechanic shop, right? So what we did, and this was a large operation, a very large operation, so it made sense for him to have these corporations although the costs associated with incorporating and maintaining these corporations were minimal compared to the benefit and to the size of his operations. But it turned out to work fabulously for him, because at some point during his operations of the business, the new car dealership was defrauded to the tune of, well, it was alleged that it was defrauded, and there was and still is pretty persuasive evidence that there was some fraud that was perpetrated on this company to the tune of about $2.1 million. A lot of creditors, the largest of which was CRA, Canada Revenue Agency. But what the benefit that accrued to him as a result of these separate corporations is that nobody, including CRA, could touch the land. Nobody, including CRA, could touch the used car dealership, and nobody, including CRA, could touch his mechanic shop. So he could operate almost seamlessly in terms of his relationship with his customers as it related to the operation of his business, right? And similarly, what you do here now let me go back to answer your question here. So here's my thought. Again, there are certain lawyers that think, for each property, have a separate corporation. And I don't think there's anything wrong with that. Although if you own several pieces of property, the cost can get, I mean, they're going to get larger than they would otherwise. But then again, if you own this many properties, it's probably a cost that you can absorb. So that's their thoughts. Here's my thought. To the extent that you own property, and let me just, before I get into that explanation, the greatest source of liability in connection with real estate ownership is our environmental issues, right? For virtually all other issues, you are insured. Insurance is a great thing. We all have it. Not as good as separate legal identity and a separate corporation. I'll quickly tell you why. So long as I've got a separate corporation that's operating this business, I am capped at my liability to whatever investment I have in that company. That's it. Okay? Whereas insurance, and I'm not an insurance agent or advisor, you guys should all have trusted insurance agents and advisors, but insurance has certain limits to it, right? There are always exceptions and exclusions to the coverage. Insurers from time to time take off coverage positions, and there are certain things that an insured party can do which would negate your coverage, right? But you have it, right? And for most things, and for most sources of liability associated with owning real estate, insurance coverage is usually sufficient. So my thought is this: so long as you guys, or whomever it is investing in parcels of property in a plan of subdivision, which means sort of what it sounds like in a developed area. I'm in London. If you're buying parcels of property in a subdivision in London or in the core in London, wherever there's a plan of subdivision, you've got a municipal address and things like that, your chances of being exposed to environmental liability is relatively limited. So it's probably safe to have more than one property in there. I think it gets to a point, there's sort of a breaking point, right? I think, because although environmental sources of liability are the greatest concern, there are other sources of liability as well. I would say once you get to a certain number, and I don't know what that number is, and it really depends on the quantum, the value of the property, but if you get up to 4 or 5, you may, and that's not an arbitrary number, a number based on experience, and other lawyers would tell you a different number. It probably makes sense to say, listen, even though I've got adequate insurance, including, additional riders and whatever, like flood damage and sewer backup and all that sort of stuff, so long as you've got that and you're in a plan of subdivision, you're probably okay to have 4 or 5 in there. If now, on the other hand, if you buy a parcel of property that used to be, God forbid, used to have underground storage tanks on them for fuel, or it used to be, used by, Shellcor or Sunoco or something like that, you almost always certainly want to incorporate a new company and keep that separate and apart from the other companies, so you don't have any cross-contamination. So I had a client call me up very recently. I can't say it was this week because it's just Tuesday, but maybe last week or the week before, and he asked me a question. He says, listen, you've incorporated this company for me. I've got a couple of different business ideas, and the business ideas, sorry, they escaped my memory right now. But anyways, his question to me was, can I operate these out of the same company? So the proper legal answer to that is yes, you can. You've got this separate legal person there. It can operate as many businesses as you want. But to the extent that you believe that one of the businesses may attract liability that you're not sufficiently insured or otherwise protected for, because there are other sources of protection other than insurance and creating a separate legal identity, a separate corporation. To the extent that you think that one business, not one party, one business has a higher exposure to risk, then it makes sense to separate these businesses into separate corporations, similar to the example that I was setting out before about my client who was in the car business. Because if something happens, and by something happens, I mean one of the businesses attracts liabilities, you want to silo that liability as much as you can in this separate corporation.
And also, this is a question of how much equity we have in these properties, the amount of, because they can only pursue what's in there, right? So if these properties were all completely paid off, then that would be the exposure. If they're partially paid off, if there's a small equity position, we'd have to measure that against the liability also. So we want to make sure we get all these questions.
So just really quickly, Anna, what's that, Montreal? So Anna, you say, can you run wholesale deals through the holding corporation, the top one that normally is inactive, or it should be through the second one, the active consulting corp? Yeah, well, I think it should probably be the real estate holding corp. So the answer to your question is, can you run the wholesale deals? Yes. I don't think there's much wisdom in doing that. One of the benefits of having a holding corporation is, again, you can get sued because anybody can sue anybody at any time for any reason, but you're limiting the exposure and the risk that if you do get sued, you will suffer any damages or losses because you're not doing anything. You're in an active business, right? It's a passive investment. What you're doing by running a wholesale deal through there, entering into contracts through there, exposing yourself to third-party liability, is exposing the assets of the holding company to the liability associated with that real estate deal. I've got a client who owns businesses in Chatham, London, and one or two other locations. He's in retail, and I found out recently during a reorganization where shares were being transferred, a corporate reorganization, I found out that his holding company owned real estate. And so he and I, and his wife's actually a lawyer, she's not a corporate lawyer, she's, I think, a general practitioner, and we had this conversation saying, listen, you're crazy to be doing this because the real estate exposes itself to certain liability, and now if it does attract liability, if that liability manifests, if that liability materializes, you're exposing all of the assets in that holding company to the liability associated with this wholesale deal. In his case, it was with this real estate right now, especially if you're owning real estate, you're entering into lease agreements, you've got third parties walking in and out, you've got slip and falls, you've got environmental issues, you've got municipal issues, you've got, a bunch of things that may attract yourself to liability. Listen, here's the way that I think about it. I'm an extremely risk-averse person. Here's the way I think about it. All of us, I think all of us, have house insurance, right? I've had house insurance for as long as I've owned houses, right? Thankfully, I've never had to use them, and hopefully, I'll never have to use them. But God forbid if I ever do have to use them, I'm extremely glad that it's there, right? And this car dealership client, and there are others. I'm just using him as an example. This car dealership client, when he was beset, or when his new car dealership company was beset by this massive liability, it was millions. Like I said, he was defrauded for about 2.1, but his exposure to liability was much greater than that. He was realizing throughout the years, and he was running for several years, he was operating for several years, he realized significant tax advantages, tax savings, tax deferrals, significant. Didn't realize as much of the liability protection associated with the structure that we set up. But I'll tell you, the difference between where he's at now and where he otherwise would have been because of this structure is night and day. He would have been completely penniless. Completely impecunious, out the door. Everything is exposed, and they would have gotten everything too, because the number the quantum of the liability was through the roof.
Just want to double check, Ed. So we're not going to run that out of the holding company. Would the consulting be the preferred or the real estate?
I think it's the real estate, right? I do
Okay.
leave all the real estate in there.
In the real estate, and this is, we're talking about a wholesale deal, so there's no ownership of it. We're just doing a transaction. So would the transaction be better for tax reasons?
Yeah, for tax reasons, you're going to have to ask the accountant.
Yeah,
but just in terms of liability, it makes sense to run it through there.
Okay.
Even though you're not going to own it,
Sure.
you still have liability,
Sure.
contractual breaches, termination of agreement.
Sure.
You probably have refs and warrants in the agreement and
I think-
corresponding indemnity obligations. You don't want those to be anywhere near.
And the main point I think that Ed made clear is wherever we decide to do that, we have to recognize that it's going to allow or expose any liability to whatever's inside that corporation. Okay, great. Just want to quickly, just before we forget, about Michael. Michael, when you said, I'm sorry, should I create the corporation before I put the property under contract and use the corporation name for the contract, or the contract and use my name for the contract and transfer the title of the corporation, or just answer my next question? It's like, look, Michael, you can put the property in your own name, ensuring that you have some sort of ability to transfer, sign that contract to a corporation that yet hasn't existed. But what Ed was saying,
but that will exist on registration of title.
Right.
It needs to exist, right? You can't
before the close.
Transfer it later. You can transfer it later, but like I said, there are tax implications, right?
You want to avoid that.
So it could be an appreciation in value, so there may be capital gains, because it probably, if it's an investment, it's going to be the capital gains. You're not going to have the principal residence exemption, and so there are issues. I mean, they're not sort of issues that you can't manage, but it makes sense that if you're going to engage in this sort of investing, to do it right from the beginning.
Okay, so we have the question about joint ventures, setting up from Timothy. When putting a joint venture together, is it better for us to use to start a specific company that we own together, or do we just have our own companies and just use an agreement between us?
Yeah, well, I mean, a joint venture requires an agreement between you, right? I mean, otherwise, what are the terms between the parties, right? So it's a difficult question for me to answer. I'll answer as best I can, and maybe you can provide more information, just because the term joint venture has a distinct and limited meaning in law. It's not a partnership. It's not, I mean, there are a lot of different sorts of business vehicles you can use, and then, excuse me, and a joint venture is one of them. So if you mean what is meant in law by joint venture, then you could hold, keep in mind what I was saying before about liability associated with environmental and other matters. I often see joint ventures when it comes to commercial properties. Commercial properties are more likely than residential properties to have environmental issues. That doesn't mean at all that environmental issues don't beset also residential properties, but commercial properties, I see it more frequently, so that's something you have to turn your mind to. But to the extent that you've had some environmental, whether a phase 1 or phase 2 done, and it's clean, or it's going to be clean, then it may not, and again, there are tax considerations here, so don't take this sort of as gospel. You can certainly from a legal perspective, but from a decision-making perspective, you've got to look at all the issues, right? And those are the two big ones. There's no reason that I foresee why you couldn't use the real estate holding company to be the joint venturer that would enter into a joint venture agreement, which is set out myriad issues: management and control, how profits are, when it terminates, how profits are divided between the parties, what role each party has, what rights, transferring joint venture interests.
I just want to jump in real quick, and I think this is an important point. See, without specifics and understanding the impact of those specifics, it would be difficult and challenging to give a specific answer to it with a general question. So I would say, that what Anand's trying to point out is he can give a general answer to it, but we want to make sure that when we're talking about setting up those corporations for the specific setup for partnership, we'd want to measure, based on the specific situation, what structure is set up. You're just seeing a picture I just drew it where you have a company, they have a company, and a third company is created where there's shareholders in that company to separate some liability between the two individuals and
Let's go down. Michael had a question.
Yeah, assets being done. So I think that This is, again, the reason we want attorneys, participating
So Mike says,
in those setups.
okay, Mike says, okay, sorry, should I create the corporation
We
before I
just
put
went through that, yeah.
Okay, but he
Yeah.
asked, can the consulting company be a construction company, or is it better to stay a consultant? Well, again, the answer is yes, it can, because it's a separate legal person, and it can engage in many business ventures as it wants. We have a lot of clients that are construction companies, and the construction business is fraught with litigation and disputes. Construction contracts, and I've done my share of them, construction contracts are notoriously not drafted well. They often use a form of contract called the CCDC, the Canadian Construction Document something, and they have a form contract that they use, and God forbid a lawyer should ever go in there and make amendments, and I've made my share of amendments, and I'll fight for them, I'll advocate for them, I think they'll make sense. But contractors are often married to those sorts of contracts, and they're just not well drafted contracts. So I would recommend, so the answer to your question, can you? Yes. Should you? Probably not.
So I think that we're at,
so it's just, Suen?
Yes, Suen, yeah.
Sorry, Suen. Suen, every time when we buy a new property, we should form a brand new R, right? Not necessarily. A real estate holding company, I think, is what you mean by R. Not necessarily. We addressed that a few minutes ago. You certainly can, and some lawyers certainly recommend that you do, and there is some wisdom in that, absolutely. I don't normally recommend it unless my clients are extremely risk averse. You have to take into consideration the risk tolerance of your client as well. And for clients that are extremely risk averse, it makes sense, the cost of incorporating another company, which would be in that pyramid where we had H at the top, the holding company, and then flowing down from there, the consulting company on the left, the real estate holding company on the right. You would just have another R there that just holds another property, right? I don't know, and I don't think there are any tax benefits of doing it that way, but there certainly is, without a doubt, some liability protection for doing it that way. I would never say that one was wrong for doing it that way. I just don't know that the incremental benefit of another company, the incremental liability protection benefit, is commensurate with the cost associated with it. To the extent, again, that the client is extremely risk averse, then I wouldn't object.
Okay.
Does that answer everybody's question so far?
In terms of getting a mortgage, how would the financing be if we put the property under a corporate name? So the property, are you talking about, Faith, the ownership of the property and who would be holding the financing? Is that what you mean? Yeah, okay. So
yeah, I mean, so listen, and this is, I often have disputes with lenders about this. And I've won some of them, but I've lost my share too. So here's my position. My position is that it shouldn't affect the financing at all, right? Lenders are concerned about, I think, primarily two things. One, what's their rate of return, usually reflected in the interest rate, right? And what security they have to secure the repayment obligations of the borrower, right? And as far as I'm concerned, whether the borrower is an individual or a corporation, it shouldn't matter, right? Whatever the rate of interest is, it could be the same for an individual, a human borrower versus a corporate borrower, and your security is exactly the same. It's the property. It doesn't matter in whose name it is. I mean, I've seen transactions where properties that weren't even held by any of the parties to the transaction were used as security. A family member, a father, a brother, an uncle. Somebody owns another parcel of property, and they use that as additional security. One means that I've used, and I don't like to do this at all, but to the extent that the client's agreeable after legal advice, I'm fine, is to have the corporate entity be the borrower and the owner, and then provide a personal guarantee. And if anything, financiers should be more content with that than simply having it in the individual's name, because now the lender has two pockets in which to try to get some cash, right? Each of the individual who's a guarantor and the corporate entity that owns the land. Does that make sense, Suen?
Just so you remember, obviously, I mean, this is something we've talked about, but I mean, something to keep in mind. Remember, the property, a mortgage, or the loan against the property is not the ownership of the property. It's just a lien registered against the asset, the property, as
It's just
security
a
for the
interest.
loan. Yeah,
All it does is
Yeah.
it secures obligations.
And that can come from anywhere.
Most of those obligations are payment obligations, but there are other obligations as well. It secures repayment, right? So you go out, you get a car, you pay $5,000 down, you owe them, that's in the car context, same exact thing in the house context. They both have registration systems. You pay, $5,000 down, you owe them $30,000 over 5 years, you fail to pay. They have a security interest. They have an interest, not ownership. With ownership comes a whole bundle of rights, but they have an interest in that asset. And that interest is in the event that there's a default, usually a payment default, but there are other defaults as well. And to the extent that there is a default by the borrower, then the lender would have, under the legislation, if it is a house under the Mortgages Act, if it is other property in common law provinces, including Ontario and every province in Canada other than Quebec, property is separated into two types of property: real property and personal property. Real property, land and buildings, and anything affixed to land and buildings. Personal property is just defined to be anything else.
Okay, so Dave was saying the H or the holding company holds the cash, does the financing, and holds the mortgage. Well, I mean that's.
Well, whoever lends the money,
whoever
lends the money.
Yeah.
So the mortgage is just mortgage. Think of mortgage as security, right? Security for the obligations of the borrower. To the extent that the holding company was the one lending the money, then it would be the mortgagee. It would be the one with the benefit of all the security rights. To the extent that there's bank financing, I've never seen a bank who doesn't want to be first in line, and I'll explain what that means in a sec. The bank would hold the mortgage security and have rights to the property. What I mean by first security is you can have multiple secured lenders, right, or secured parties. They don't even have to be lenders, secured parties. And how priority works is it who registers first has priority, subject to a contract being entered into between the lenders, has the first ranking priority. So if you buy a building for $1 million and I lend you $500, I register first. If Sam lends you $300, he lends you second. Unless Sam and I enter into an agreement, called it usually a pari passu agreement, which just means a sharing agreement, a sharing of proceeds of the property. Unless we enter into that agreement, then I, as the first party that registered a mortgage, and registration is just based on date of registration. If I registered first, I have a right to the outstanding amount first. If it's $500, some amount less than that. If some of it has been paid off, and then after that, if there's anything left, it goes to Sam. If Sam gets his $300, anything after that goes to any subsequent mortgage holders or secured parties. And if there's any balance after that, which there usually isn't, then that goes to the owner of the property.
So first in, first out. So Justin, would you recommend that we set up separate corporation for fix and flips, or do you think it would be better to keep them owned in your own name? Well, my view is I would never want anything owned in my own name. You know how I feel about that. I think that a corporation, the real estate corporation, or a separate corporation, if you want, that's up to you. But I would, especially, a fix and flip could attract some new liability or additional liability because of the nature of the strategy itself. Do you want to?
So just let me just respond to Faith quick because I'm over time here. But So Faith says, okay, thanks, because I was told by one lawyer that it is harder to get fined. And listen, I don't disagree with that, Faith. I don't disagree with the proposition set out in your message there, right? What I said was, or what I tried to say was, I don't get the principle behind that. I don't get the logic behind that. For whatever reason, and banks are set in their ways, and banks who are usually lenders, unless you find a private lender or some other source of financing. They usually avert from that. Again, I don't understand the logic behind it, right? Because again, what they're seeking to, what their concerns are, what their interests are. Okay, forget about what position they're putting out there. You know what I mean? No, we won't lend to corporations like we do to individuals. We want a higher percentage down payment. We want higher interest, whatever. I don't understand it, and I've never had anybody, and I've had this tussle quite a few times. I don't understand the logic behind it because, like I said, there are two principal interests. What's my rate of return, right? And you can get that same rate of return from this artificial person, this corporation, which is, again, a legal person, or an individual, right? And the second interest is, well, what happens if I don't get paid? What happens if the market goes to, what happens if there's a default? Well, your rights are not, your rights against whom don't matter. Against the corporation, against they don't matter. The rights are in what the asset is, right? That's all I really care. I'm doing a deal right now where we're taking a a client of mine is a lender, and he's taking a security interest in basically a book of, not really a book of business, receivables, right? So at the end of the day, we don't care about, so we're doing a due diligence now. Actually, tomorrow, Wednesday, the client's going to review all the receivables. They're at around $2.7 million. We want to go in, we want to see the receivables, we want to do some accounting ratios on them, we want to see how they've, the repayment, how the repayments have been made. And the lender, and the borrower in this instance is a corporation. The issue of the lender in this deal that we're doing, which is, I think in total about a $7.5 million deal, never came up. Never came up once. The issue of the lender being a corporation hasn't come up. Now, there's additional due diligence that you do with a corporation, right?
Absolutely,
you want to see the articles of incorporation in order to determine the authorized shares. You want to see the minute book of the corporation in order to see the issued shares. You want to see any shareholder agreements. You want to see any characteristics of the shares.
Any liability.
You want to make sure. Yeah, you want to make sure.
You have employees, if they had employees or something that they would be obligated, if they were obligated to them.
Right, but all of those creditors, employees, although there are some statutory liabilities associated with the employees, not a big number, but anyways, all of those liabilities are deemed to be in law unsecured creditors, right? You, a mortgage holder, a mortgagee is a secured lender, and in terms of priority, if there's an act of bankruptcy, if there's a default, secured creditors always get their money first. And oftentimes, unsecured creditors are getting, if anything, and oftentimes they get nothing, if anything, they're getting pennies on the dollar, right? So all these other liabilities aren't much of a concern to us. You know, and we'll look at them because we want to know how leveraged this person is. And if they've got loans left, right, and center, which are secured, we know that, okay, we're either going to be standing subsequent in priority, we're going to rank lower in priority with them. In this, just quickly, in this instance here, there are 3 secured creditors, one of which is an institution, one of which is a related party to the vendor, and another of which is another institutional lender. So we're purchasing the shares of one of the institutional lenders, all right? So we're taking an assignment, a transfer of the security interest, and we're stepping into their shoes, so we're fine. We're down now to 2 secured lenders. The secured lender that's a related party, it's a corporation that was incorporated by the owner, we've told him in no uncertain terms, and we've faced no opposition, we want you to subordinate, which means even though they registered first, we will enter into an agreement between us, and we'll register this agreement in the registration system, the PPSA registration system, which agreement will say, notwithstanding the fact that this lender, this related party lender, registered before us, and by principle of law, they secured rights, rank and priority to us, they are subordinating to us such that if there is a default or act of bankruptcy, we would get our money before they do.
Adnan speaks like he's reading a contract because this is what he does. No, there's nothing wrong with this. This is important. So
I hope everybody's getting this, and if there's any questions that flow from this, let me know.
Yeah, and then this is recorded, and you'll be able to review it. What I really want everyone to understand is the complexity of law and how it's something that we really do not want, in my opinion, do not want to take on without the proper education and certification. I mean, there's a reason that Ed went to law school and got his degree and his law degree and practices for the last 15 years. So I think that's the bigger message for everybody. Make sure you get legal advice, proper legal advice, because the complexities really are lost on the average individual. And even the individual that's an active investor and participates in these contracts with lawyers, the lawyer still is leaps and bounds, the Grand Canyon between you and them, and understanding really the exposure of liability and the benefits or non-benefits of setting up your business in a particular way. That's why it's on a case-to-case basis. So it is 10:30 right now. We're going to wrap up. Unfortunately, we didn't get a chance to talk to Tarek. So we're going to move Tarek to next week, if that's okay, Tarek. Yep, that's good. All right, so Tarek's going to join us next week. I want to thank everyone for coming. I want to thank Adnan.
I want to apologize for monopolizing the time, but you know what they say about lawyers, eh? We get paid by the word.
So what we're going to do is this, anyone who has further questions, and this is what I want everyone to understand. Don't send this to Bill yet. I want everyone to understand. When I bring these individuals on, I want you to take full advantage of those general questions that you have, or any questions that you have on the call. If you're reaching out them specifically, I want it to be a specific situation with with you understanding that they're not there to answer general questions. As a resource that way. I want the Tuesday calls to be done for that. If you wish to do business with them, that's totally up to you. And I mean, that's something that you can decide through your own vetting process and your experience with them. So if you would like, is it okay? Would you guys like Adnan's email address if you don't have it already? Yeah, okay. Adnan, do you want to just, so here, yeah, just type that in, and then we'll wrap up. He's got to go to the box. There you go. Again, use this, wisely and efficiently, and on your own accord, decide if that's what you want to do business with Adnan or anyone else. Obviously, I'm just a big fan of proper legal advice. It's up to you to take responsibility for that. I want you to understand that I'm telling you need to get legal advice when you're participating in contracts and setting up these corporations to protect yourself. Under no circumstance do I think it's something that you should do on your own. So Adnan's located in London, Ontario. Siskins is a renowned, I'll say it, renowned and top law firm in Canada. They cover a bunch of different types of law. Right now, where the focus is, well, actually, Ed, why don't you tell them what kind of laws you guys practice, your organization?
Oh, I mean,
or how about don't practice?
About the only areas where we don't have expertise is criminal law and immigration. God forbid you ever need a criminal lawyer. I could certainly refer you to one in terms of immigration law, which is wholly unrelated to what you guys are doing. But I do have an individual who's a partner of ours at the firm who has since moved out, who's a fabulous immigration lawyer. But otherwise, we have, across the board, corporate, franchise, intellectual properties, patents, personal injury, employment, family, civil litigation, commercial litigation, labor law. You name it, and
right.
We have that expertise.
Okay. Yeah. So, Adnan, can you practice law across Canada?
So any lawyer who's licensed to practice law, again, we're talking, and I should have said this maybe at the beginning. My comments should be restricted to the common law provinces. So any province other than Quebec. Quebec is just a different beast. Anytime we do a deal where there's a Quebec element, I'm doing one right now where we're purchasing a business in Quebec, we always get Quebec counsel. But otherwise, we're able to, and not just Canada, much of the world is has common law jurisdiction. We have expertise in that area.
Thanks again, Ed, as a group. Spectacular. You got us to reach here.
Oh,
so,
thanks.
Thank you very much.
Thanks, Ryan.
That's nice. Nice to say. Okay, so we're gonna wrap it up. Any last? We good? Okay, good. If you're good, type in yes or Y. Excellent. Great group. I'll have this up in the next couple of days. If you have any other additional questions, you can reach out to me. If you have specific questions for the sake of setting up those corporations or contracts, participating in setting up the contracts or agreements with you or yourself, you or other individuals, get legal advice, reach out to the proper people, make sure your team is taken care of, and they'll take care of you. And don't try to figure it out on your own. Even Adnan talking about, the fact that when they were working with a Montreal business, even the lawyers get lawyers, right? This is important. When you're out of the scope of what you understand and know to be sure, you should get the professionals to assist you in that. So we're going to wrap up. I want to thank everybody for coming out, and have a great week. If you need anything else, you know how to reach.